Swayam Prabha. Digital India. Educated India.
Hello everyone, this is Dr. Shabnam Mehlawat from the Faculty of Law, University of Delhi. This is my lecture number 17 and I will be informing you about the noise pollution, the legislation relating to the same, which is the Noise Pollution Regulation and Control Rules, which were enacted and came into force in the year 2000, the concepts under the law and the regulations, and the rules and the cases as they apply into the Indian conditions. I would like to introduce you to the topic by referring to the International Convention, which deals with the protection of atmosphere and especially with provisions relating to those causing detrimental harm when noise pollution is created. So this is the Working Environment Air Pollution, Noise and Vibration Convention of 1977, number 148. It is a convention which is backed by the International Labour Organization and is applicable to all member countries who have accepted the convention, who are signatories to the same. They have ratified the same with reference to the protection of environment in these forms, which is prevention, control and protection against occupational hazards leading to air pollution, noise and vibration in the workplaces or otherwise in the daily routine or in the daily life of all living organisms, which is, it also relates to activities specifically to the land, to the marine areas, and it is already an atmospheric problem when noise pollution, which is created in the form of noise, which is more than what is required to be heard by a living being. If it goes beyond the limits to which it is prescribed, it may cause detrimental harm, which is loss of hearing amongst human beings, animals, or other living beings, and which leads to your violation of the right to life. So this is also referred to as the C-148 Working Environment Air Pollution, Noise and Vibration Convention 1977, number 148. These provisions speak of as having adoption of protocols with regard to working environment. Atmospheric pollution, noise and vibration is considered as the fourth item on the agenda of the session to form a part and parcel of the International Convention for implementation purposes. It was adopted on the 20th June of the year 1977, the following convention, which may be cited as the following. It was to take measures for the protection of health and hygiene of the workers and those who would default, that is, the owners, the occupiers and the industrialists who allow people to work in their organization in any form should not subject its workers or employees to certain health hazards of noise pollution. If the noise pollution goes at a level which is more than the prescribed limits, causing harm to somebody, then the owner or the industrialist or the occupier will be responsible for the health and the condition of that person who might be affected. Each member, after the consultation with the representative organizations of the employers and workers, where such may exist, may accept the obligations of this convention separately. So there are certain specific areas where noise is a part and parcel of the activity which takes place. For example, in cases where mining takes place or where in industries you need to work with iron ore or heavy industry which requires noise levels to go beyond prescribed limits, then the owners must take the requisite precautions for their employees to have a proper equipment so they are not subject to unnecessary harm. This unnecessary harm, if they are subjected to, and it causes any health or issue or problems in the workers or the employees, then the employer is liable for the same. The other international initiatives are the Environmental Noise Directive, or the END as it is referred to in short, The European Union established the Environmental Noise Directive to identify noise pollution levels and take action to mitigate them. It has 4 key areas which are determining the exposure to environmental noise, which is assessing health effects of the individual dwelling level, developing action plans to reduce noise exposure, and informing the public about noise levels and their impact. So, with these 4 key areas of determination of the exposure, that is making an assessment of the activity which will produce certain amount of noise levels and which is, if exposed to the environment, may cause harm to which they are subject to. So, the person conducting such an activity should take precautions in reference to the same, and he should also assess the health effects of the person or the dwelling or any other reason whereby the other person is subject to such noise levels. He should develop plans to reduce that noise exposure, maybe mechanisms, maybe machines, maybe technology, or protectionist measures like of some equipment which prevents the employees from not listening to those levels of noise which will subject to problems like hearing loss or other health issues in the employees. One should also inform the public by creating an awareness that levels which go beyond a certain limits of the noise pollution, it will be causing harm and thereby affecting the health of people. The effort is of the world community to go in consonance with the international conventions and develop laws within the domestic arena of their country on the same lines which are done at the international level. Some of these efforts made by certain countries are the United States, the Noise Control Code 1972 at the federal level, as well as the state-specific codes like the New York Noise Control Code 1972, Chicago Noise Control Regulations 1971 help control the noise pollution. In Great Britain, the Control of Pollution Act 1974 covers noise pollution within its Part 3. Japan has the Noise Control Laws of 1968 to tackle noise-related issues. In India, we have the Noise Regulation and Prevention of Control of Pollution Rules in the year 2000. So, the word noise, it comes from the Latin word term nausea, which means seasickness. In the ancient societies, when these terms and phrases were developed, it was in relation to the activities which were conducted at that time. So, it was only the seafaring countries and the sea-related activities which went on to create certain terms so as the interpretation of those terms becomes easy, whether it was the seafaring, whether it was land, or whether it was air. They had certain terms which meant or had a legal meaning later in the legislations of each respective countries. So, we do follow the meanings as per, say, the dictionary or as per given under any other law which is applicable to all common conditions of a certain problem. The sound that is unwanted or that disrupts the activity or the balance of human or animal life is called noise. When there is a lot of noise in the environment, that is, it goes beyond certain levels, it is a term which is given as noise pollution. There are many sources of noise pollution which are associated with transportation, urban development, industrial activities, and the neighborhood and recreational noise. The latest to form in the category of noise pollution is very important is the recreational noise. That means noise levels by which music or other activities are carried out in such a high scale that it affects the living activities of the people who are not a party to the same or who are also subject because they are within the vicinity of such noise levels. In the recent years, noise has emerged as one of the important pollutants under environmental laws. Noise is that if under the Indian laws, we have the Environmental Protection Act of 1986, the Air Pollution Act of 1981, and the criminal laws which have recognized that noise pollution created under any one of the laws and is subject to one of the conditions which are specified as offenses under that law, the person who's conducting the same will be punished accordingly. Now, under the Environmental Protection Act, there are no provisions which deal specifically with the noise pollution, but it has two provisions which deal with that for the purpose of creation of those rules and regulations and guidelines which might be created by the government, which may be the central government or the state government, to deal with activities which relate to noise pollution. If looking at section 6 of the Environmental Protection Act, it provides for rules to regulate environmental pollution. The central government, by notification in the official gazette, may make rules with respect to any one of the matters or all of the matters related to environmental acts. In particular, and without prejudice to the generality of the following, the power to create such rules may be for the standard of quality of air, water or soil for various purposes, the maximum allowable limits of concentrations of the various environmental pollutants for different areas. Then, the procedure and safeguards for the handling of these hazardous waste, or the prohibition and restrictions on the handling of hazardous substances in certain areas, the prohibition and restriction on location of industries and carrying on the processes and operations in different areas, and the procedure and safeguards for prevention of accidents which may cause environmental pollution and provide for remedial measures for such accidents. So, under provision under section 6 of the Environmental Protection Act, it has a general provision, but it allows the central government to create rules for the purpose of, firstly, the drafting in a manner which protects the citizens from violation of their fundamental right of Article 21, which is to maintain certain quality of noise levels which do not affect the citizens adversely. It talks about the noise rules which create certain maximum allowable limits for certain areas, that is, there may be areas where industrial activities may take place, there may be residential areas, there may be hospitals and schools where they are referred to as the silent zones, where no level of noise is allowed because it is to the detriment of such areas that if noise is allowed in these areas, it would be harmful for the patients or for the school children who are studying in the schools. So, it is the procedure and a safeguard which is established under the law by the creation of those rules. There is prohibition and restriction in certain areas of the allowable limits which need to be allowed for the purpose of creating noise. And there is the location aspect for which only certain levels of noise will be allowed. The safeguards ensure that these remedial measures are put into place and do not cause harm to the fundamental right of a citizen who is protected under the Indian law under our constitutional law of Article 21. This is also subject to Article 19(1)(g), which says a person has the right to carry on his trade and profession, but it is subject to certain restrictions or regulations which says the right to carry on your trade and profession cannot override the right to life. Meanwhile, the directive principles of the state policy talk about the duties of the citizen and duties of the state under Articles 47, 48A and 51AG, which specifically also talk about the protection of environment in several ways, and the creation of noise pollution is harmful to the environment. That is, if noise levels are created, even nature is disturbed by the very creation of those levels. Then comes the right to constitutional remedies, where a person may file a case for the protection of his right under the right to constitutional remedies of Article 32 and 226, where public interest litigation may be filed by a person on behalf of the remaining people. It is a collective or a community right which is claimed under a PIL when it is filed. So, the rules which are there under the Environmental Protection Act are Section 6, as I said, and Section 25 of the Environmental Protection Act. Section 25 talks about It is the power of the central government to frame rules for the standards, for procedures to be established, for authorities or agencies to be created, for the manner in which the samples may be collected for the purpose of assessment and analysis. Laboratories may be created by the government where the samples which are so collected are sent, and the functions of these laboratories where they prepare reports and send them to the appropriate authority for them to take decisions. The report of these analysts is also important since it also creates evidence for these cases to be tried in the courts, and the courts also can come to a decision when a report is prepared by an analyst in a laboratory, for it serves as evidence for the court to see whether the pollution which has been created is within the limits set by the law or they have exceeded those limits and the offender ought to be punished. There are authorities or any other related issues may be created under Section 25 of the Environmental Protection Act. These rules are also acknowledged under the Air Prevention and Control of Pollution Act 1981, that it is a sort of an air pollution which is created when noise levels grow beyond certain decibels which are of the allowable limits and they exceed those limits, creating those levels. Noise pollution is also a part and parcel of the criminal law where public nuisance is created, and under the provisions of Section 268, 290 and 91 of the Indian Penal Code, and earlier till the current amendment in the current laws on the criminal liability is yet remains to be seen. But prior to these amendments which have been made or prior to the new law which has been formed, it was Section 133 of the CRPC by which public nuisance was dealt by the courts to deal with any kind of pollution that may be created in the environment. So the noise pollution rules themselves now. I will be going and evaluating over the noise pollution rules as they are created. The creation, the specifications, the procedure which is to be followed, and the allowable limits which are given under these rules. Although they are framed under the aegis of the Environmental Protection Act, because it specifically mentions so that it will be taken up under Section 6 and under Section 25 of the Environmental Protection Act. The objective of these rules are where the increasing ambient noise levels in public places from various sources, inter alia, industrial activity, construction activity, generator sets, loudspeakers, public address systems, music systems, vehicular horns, and other mechanical devices have a deleterious effect on human health and psychological well-being of the person, it is considered necessary to regulate and control noise-producing and generating sources with the objective of maintaining the ambient air quality standards in respect of noise. The drafting and making them applicable, the drafting of the rules, and we are making them applicable. Where a draft of the Noise Pollution Control and Regulation Rules 1999 was published under the notification of the Government of India in the Ministry of Environment and Forests, wide number SO 528E dated 2nd June 1999, inviting the objections and suggestions from all persons likely to be affected thereby before the expiry of the period of 60 days from the date on which the copies of the Gazette containing the notification are made available to the public. Therefore, in exercise of the powers by Clause 2 of Subsection 2 of Section 3, Subsection 1 and Clause B of Subsection 2 of Section 6 and 25 of the Environmental Protection Act, read with Rule 5 of the Environmental Protection Rules 1986, the central government hereby makes the rules for the regulation and control of noise producing and generating sources. Section 4 talks about these rules, that is, unless the context otherwise requires. An act means the Environmental Protection Act of 1986. So these are the defining terms. Whenever these words are used in the studying of the law or the legislation, these meanings are important for the purpose of interpretation of the law when they are made applicable. An area or a zone means all areas which fall in either of the four categories given in the schedule annexed to these rules. Authority means any officer or authority authorized by the central government, as the case may be, the state government in accordance with the laws in force, and includes a district magistrate, police commissioner, or any other officer not below the rank of a deputy superintendent of police designated for the maintenance of the ambient air quality standards in respect of noise under any law for the time being in force. Court means a governmental body consisting of one or more judges who sit to adjudicate disputes and administer justice, and includes any court of law presided over by a judge or judges or a magistrate, or acting as a tribunal in the civil, taxation and criminal cases. Educational institution means a school, a seminary, college, university, professional academies, training institutes or other educational establishments, not necessarily a chartered institution, and includes not only buildings but also the grounds necessary for accomplishment of the full scope of educational instruction, including those things essential to the mental, moral and physical development. These definitions are important because the noise levels created in these institutions or places are required to be regulated, and certain limits are prescribed for these areas. Hospital means an institution for the reception and care of sick, wounded, infirm, or aged persons, and includes government or private hospitals, nursing homes and clinics. A person shall not include any company, association or body of individuals, whether incorporated or not. The state government in relation to the union territory means the administrator thereof appointed under Article 239 of the Constitution. A public place means any place where public have access, whether as of right or not, and includes auditoriums, hotels, public waiting rooms, convention centers, public offices, shopping malls, cinema halls, educational institutions, libraries, open grounds, and the like, which are visited by the general public. The night time means the period between 10 o'clock in the night and 6 o'clock in the morning. These definitions are important because even in public places, when the public sound systems are to be used beyond the period of 10 o'clock to 6 in the morning, special permissions are required to be taken by the authorities for the purpose of holding any meetings or conferences or other thing of a like nature in such public places. The amended rules which came in the year 2006 are that the ambient air quality standards in respect of noise for different areas or zones, the ambient air quality standards in respect of noise for different areas or standards shall be specified in the schedule annexed to these rules. The state government shall categorize the areas into industrial, commercial, residential or silence area zones for the purpose of implementation of noise standards for different areas. So, they have bifurcated the areas into four kinds of areas. One is industrial. Industrial activities, wherever they take place, may include a lot of noise which might be created, and for that purpose, different standards or different decibels of noise levels are firstly created. And then the industrialist needs to take precautions that the noise which is present in the industry does not exceed the maximum levels, or he has taken proper precautions for his employees as well as workers to not to be subject to those noise levels which go beyond the allowable limits. In commercial areas could be offices, and commercial areas could be business centers where people are carrying on business. So, in those areas or in those workplaces or where commerce and trade takes place, those allowable limits are also subject to terms and conditions where it should not exceed those levels. Then comes the residential areas. It is very important to understand that the noise levels in residential areas should be lower for the reason that people are living in that area. The age and the limit of people are to be taken into consideration when certain noise levels are created in the form of public address systems or the music systems or other noise which might be created due to personal activities. If you are using a public address system for the purpose of conducting any event like a jagrata or a religious ceremony or something, the noise of the public address system in such areas is specifically detrimental. Religious practices can be followed even without having a loud music system or a public address system, whereby which the music or the noise which is there does not affect the people who are living. There might be aged people, there might be infirm people, and there might be children who might be studying for school or for sleeping purposes, where babies are there. They are specifically vulnerable to the creation of noise if being done or created within their vicinity. The last is the silence area zones, which are the hospitals and the schools. They are where no noise levels are allowed at any point of time, because it is the creation of a health issue which goes beyond limits and it could be detrimental, leading to the ill health or the death of a person. So the state government has to take measures for the abatement of noise, including noise emanating from the vehicular movement, and ensuring that the existing noise levels do not exceed the ambient air quality standards specified under the rules. The measures which are taken by the government: the state government shall take measures for abatement of noise, including noise emanating from the vehicular movement, blowing of horns, bursting of sound-emitting firecrackers, use of loudspeakers or the public address systems and sound-producing instruments, and ensure that the existing noise levels do not exceed the ambient air quality standards specified under these rules. So important are the vehicular movements, blowing of horns, emitting firecrackers, loudspeakers, public address systems, and the sound producing instruments. All development authorities, the local bodies and other concerned authorities, while planning developmental activity or conducting or carrying out any functions relating to the town and country planning, shall take into consideration all aspects of noise pollution as a parameter of quality of life to avoid noise menace and to achieve the objectives maintaining the ambient air quality standards in respect of noise. Any area not less than 100 meters around hospitals, educational institutions and courts may be declared by the central government as a silence area or a zone for the purposes of Rule 3 of the law, provided an area shall not fall under the silence area zone category unless notified by the state government in accordance with sub-rule 2. So these rules or these zones need to be specifically declared by the government and be officially notified in the official gazette for the people to know which area is covered under what level of noise levels. Responsibilities of enforcement and restrictions on the use of public address systems. Section 4 talks about the responsibility as to enforcement of noise pollution control measures, which is the noise levels in any area zone shall not exceed the ambient air quality in respect of noise as specified in the schedule. Authority shall be responsible for the enforcement of noise control measures and compliance of the ambient quality standards in respect of noise. Section 5 talks about the restrictions on the use of loudspeakers or the public address system. A loudspeaker or a public address system shall not be used except after obtaining the written permission from the authority. And in the states and in the district levels, the authority is usually the Deputy Superintendent of Police or the police authorities, where they are authorized to take the permission into account while dealing with the events. A loudspeaker or a public address system shall not be used in night between 10 to 6 p.m., 10 p.m. at night to 6 a.m. in the morning, except in closed premises for communication, that is in an auditorium, conference rooms, community halls, and banquet halls. Notwithstanding anything contained in Sub-Rule 2, the state government may, subject to terms and conditions as are necessary to reduce the noise pollution, permit the use of loudspeakers or the public address systems during the night hours between 10 to 12, only on or during the cultural or religious occasion of a limited duration, not exceeding 15 days in all during a calendar year. Now, it is during the Diwali festival that India has a system of public address systems being used publicly. So, they are only allowed up till 10 o'clock in the night. If they wish to run their activity beyond 10 o'clock, the maximum allowable limit is 12 o'clock, and that also can be conducted with prior permission which comes from the district authority, which in turn takes that permission from the highest authority of the state, where the chief minister of a state has to provide that permission to all areas for running those public address systems till 12 o'clock in the night during that festival time. The explanation clause. The explanation clause talks about that the festive occasion shall include any national function or a state function as notified by the central government or the state government. National function or state government shall include the Republic Day, the Independence Day, the State Day, and any other day which has been notified. The noise level at the boundary of public place where loudspeaker or the public address system or any other noise shall not exceed the 10 decibel amount above the ambient noise standards for the area, or a 75 decibel amount whichever is lower. So, the levels of noise pollution or the noise levels are calculated in decibels, which they say should be between a particular decibel for them to be the maximum or the minimum limits which are allowed for creating noise. The peripheral noise level of a privately owned system or a sound producing instrument shall not at the boundary of the private place exceed more than 5 decibels, the ambient noise standard specified for the area in which it is used. The amended provision talks about there are restrictions on the use of horns in our vehicles, sound emitting construction equipment, bursting of firecrackers. It says no horns shall be used in the silent zones or during the night time in the residential areas except during a public emergency. Sound emitting crackers shall not be bursted in the silent zones or during the night time. Sound emitting construction equipment shall not be used or operated during the night in residential areas and silence zones. Consequences of violation. Under Section 6 provides the consequences of any violation in the silence zone area. It is wherever in any place covered under the silence zone commits any of the following offences, he shall be liable to be penalized under the provisions of the Act. That is, whoever plays any music or uses any sound amplifiers or beats a drum or a tom-tom or blows a horn, either musical or pressure or a trumpet or beats or sounds any instrument, whoever exhibits any mimetic, musical or other performances of a nature to attract crowds, who burst sound emitting firecrackers, which are usually done during Diwali season, whoever uses a public address speaker or a public address system, if he is going beyond the specified limits of the decibels, he is violating the code and he is violating the rules, he shall be penalized under the law for creating that violation. The next comes is filing complaints. The complaints are to be made to the requisite authority. A person may, if the noise level exceeds the ambient noise standards by 10 decibels or more, corresponding columns against any area or zone, may make a complaint to the authority which is specifically established to listen to these problems. They shall act on a complaint and take action against the violator in accordance with the provision of the rules or any other law in force. Power to prohibit continuance of sound or noise. Under Section 8, the power to prohibit or continue music, sound or noise is if the authority, which is specifically so established, is satisfied from the report or an officer in charge of the police station or any other information received by him, it is necessary to do so in order to prevent the annoyance, the disturbance, the discomfort or injury or risk of anything, risk of annoyance, disturbance, discomfort or injury to the public or to any other person whose dwelling or occupies property in the vicinity. He may by a written order issue such directions as are necessary for the purpose of prevention, prohibition, controlling or regulating the activity. The incidence or continuance in upon any premises of any vocal or instrumental music, sounds caused by playing, beating, clashing, blowing, or use in any manner whatsoever of any instrument, including the loudspeakers, the public address systems, the appliance, apparatus or contrivance which is capable of producing or reproducing the sound, the carrying on in or upon any premises of any trade, vocation or operation or process resulting in or attended with the noise. So, the authority has the power to prevent all kinds of noise. Now, this is not an exhaustive list which is given, but an enumerative list which says anything which creates a sound beyond the requisite levels is of this kind in nature or plays music which is beyond the limit levels, he shall be regulated by the concerned authority. Authority is empowered may either on its own motion or on application person aggrieved by an order made under sub-rule 1 either rescind, modify or alter any such order, provided that before any such application is disposed of, the authority shall afford the applicant an opportunity of appearing before it either in person or by a person representing him and showing cause against the order, and shall, if he rejects any application either wholly or in part, record reasons for such rejection. Which means that if a person has created the noise levels, the authority has stopped him from working and asked him to why he should not be penalized, he will be given an opportunity to bring his cause to before the authorities. If they are satisfied with the answer as to why that noise level was created, they might acquit him. But in case he has deliberately done the same with the intention of creating that noise, then his reasons may be rejected and he may be proceeded against. The schedule of the rules. The rules contain ambient air quality standards in respect of the noise area code category of area zone limits in decibels, the daytime industrial areas, nighttime commercial area, residential areas and the silence zones. Then come the other meanings within the law. Daytime shall mean from 6 am to 10 pm and nighttime means from 10 pm to 6 am in the morning. The silence zone is defined as an area comprising of not less than 100 meters around hospitals, educational institutions, courts and religious places, or any other place which is declared as such by the competent authority. The mixed category of areas may be declared as one of the 4 mentioned categories by the competent authority. The decibel denotes the time weighted average of the level of sound in decibels on the scale A, which is relatable to human hearing. A decibel is a unit in which noise is measured A in decibels. Lek denotes the frequency weight in the measurement of the noise and corresponds to the frequency response characteristics of the human ear. The lek, it is an energy mean of the noise level over a specified period of time. Then comes the applicability of this law under the Factories Act. In India, the factories do not contain any specific provisions for noise control. However, under the 3rd schedule, sections 89 and 90 of the Act says or talks about the noise induced hearing loss. That is, The Factory Act also acknowledges that noise may be created, and for that they have made a provision under the law, which means that if a person's hearing is affected by the noise which is created in the factory, it is a notifiable disease. They have acknowledged the fact that the person who is subject to such hearing, if he is not taken proper precautions, either by the industrialist, if he himself has not taken those precautions, then the occupier or the industrialist will not be liable. But if the industrialist has not taken any protectionist measures, either for his employees or workers, and they are subject to such noise levels causing noise-induced hearing loss, then it is a notifiable disease. Under Section 89, any medical practitioner who detects such notifiable disease, including noise hearing loss in a worker, he has to report to the Chief Inspector of Factories along with all other relevant information, and if he does not do so, such failure will result in a punishable offense. Employers are required to prevent or reduce risks to health and safety from exposure to noise at work. The employees have a duty under these regulations. The employer must assess the risk to an employee from noise at work, take action to reduce that noise, provide hearing protection if noise exposure cannot be sufficiently reduced by any means, ensure that the legal limits on noise exposure are not exceeded, provide information, instruction, and training to employees, conduct health surveillance where there is a risk to health. So the regulations do not apply to members of the public who are exposed to noise from the non-work activities or those making an informed choices to go to noisy places. A person who goes to a public place is in a way accepting the harm or the hazards of that place. But he cannot still be subject to those noise levels which are exceeded beyond the required or the maximum limits prescribed under the law. A person, let's say he goes to an office place, something falls or something which is the fault of the owner or the employer, if because of his activity the person visiting is affected by any notifiable disease or a hearing loss, then the owner shall be liable for the same. So there are rules which relate to the Factories Act, that is people who are workers and employees, and then there are rules which also apply in certain manner to people who are the non-workers but are working in the vicinity of such places. They also cannot be subject to certain noise levels if, however, they enter forcefully or are trespassing in that area without knowledge that these are being subject to such noise levels, then the level of compensation which comes to such persons is reduced because of their own fault. So the low noise level, that is a nuisance but causes no hearing damage, is also exempt from this act. The noise limit for vehicles and airports. The noise limits for vehicles applicable at manufacturing stage from the year 2003 are: there are two-wheelers, there are three-wheelers, there are passenger cars, there are passenger or commercial vehicles, gross vehicle weight up to 4 ton, gross vehicle weight more than 4 tons up to 12 ton, gross vehicle weight more than 12 ton, two-wheelers, three-wheelers, vehicle used for carriage of passengers and capable of not more than 9 seats, including the driver's seat, vehicles used for carriage of passengers having more than 9 seats, including the driver's seat, and the maximum gross vehicle weight for more than 3.5 tons, vehicles used for carriage of passengers having more than 9 seats, including the driver's seat, vehicle used for carriage of goods, vehicles used for transportation of goods with a maximum GW exceeding a 3.5 tons, which have certain specifications of noise levels which first came in the year 2003 and then they were further elaborated upon in the year 2005 under the same noise pollution and regulation rules of the year 2000. Under the environmental protection rules, the Schedule 1, the entries which were inserted were the industry parameter standards of ambient air quality standards with respect to noise, and then noise in airport areas in noise zone 4 and certain type of area limits in certain decibels, the busy time airports and all other airports including the proposed airports where the noise levels at such places should be regulated and are done with the maximum limits which may be prescribed. It is for this reasons certain areas are barred for the general public in these airports, since the landing and flying of airplanes will lead to certain noise levels which the people should not be subject to, so they are prohibited from these areas from entering these places. The noise limits for generator sets which are run on diesel fuels. The noise limit for generator sets up to 1000 kilowatts manufactured on or after 1st January 2005. The permissible sound pressure level for these diesel generator sets with rated capacity up to 1000 kilowatts manufactured on or after 1st January 2005 shall be 75 decibels at 1 meter from the enclosure surface. The generator sets should be provided with an integral acoustic enclosure at the manufacturing stage itself. The implementation of noise limit for these sets shall be regulated as given in para 3 below. The noise level for these DG sets are covered by para 1. The limits of the noise for these DG sets up to 1000 kilowatts are framed in the year 2005. This requires a certification. The sale, import or use of these sets not complying with the rules are prohibited. There is a requirement of conformance which is labeling, which is done on these sets. There is a nodal agency which is established. The authorized agencies for certification of these sets, there is compliance and a testing procedure which is carried out before they are allowed to be sold. Exemption from the provisions of para 1 and 3 of the products of the DG sets up to 30 kilowatts are purchased by the Ministry of Defence in the Government of India. Exemption from the provisions of 1 and 3 of the 16 DG sets of 45 kilowatts purchased by the Ministry of Defence of Government of India, and the transportation of these sets should be above 250 kilowatts. The guidelines of the World Health Organization for noise are that the World Health Organization has given out certain guidelines. Their values are summarized with respect to specific environments and effects. Environment and situation, the guideline values take into consideration the identification of the health effects and are set based on the lowest levels of noise that affect health and critical health effect. The guideline values typically correspond to the lowest effect level for general population, such as those of the indoor speech intelligibility. Noise guidelines are for the onset of the health effects from noise exposures. The noise standards for firecrackers, which were amended in the year 2006 under the Environmental Protection Act. The manufacture, sale or use of firecrackers generating noise levels exceeding 125 decibels or 145 decibels at 4 meters distance from the point of bursting are prohibited. For individual firecrackers constituting those series, the above mentioned limit will be reduced by 5 or to 10 decibels, where n is equal to the number of crackers joined together. That is, one cracker may have several crackers joined together and they may burst one after the other. The levels of those firecrackers needs to be controlled and should be lower when they are burst during the event. The broad requirements of measurement of noise from the firecrackers shall be measurements made on hard concrete of surface of minimum 5 meter diameter or equivalent. The measurement shall be made in free field conditions, that is, there shall not be any reflecting surface up to 15 meter distance from the point of bursting. The measurement shall be made with an approved sound level meter. The Department of Explosives shall ensure implementation of these standards. The firecrackers for the purpose of export shall be exempted from paragraphs of A, B and C of the rules, subject to the compliance of the following conditions, which are conform to the levels prescribed in the country to which they are exported. They shall have a different packaging color code where the labels also project as to their specifications, and there should be a declaration on the box which says not for sale in India or only for export in other countries. So the labeling of products has become a very important norm. That is, the labels provide information in relation to the import and export of certain commodities, and these commodities may be protected. These commodities may be for the information of people who will be making use of the same, or for the authorities to decide whether an activity is legal or illegal. The Motor Vehicles Act of 1988 and the Law of Torts. The Law of Motor Vehicles Act under Rules 119 and 20 deal with the reduction of noise in these vehicles, which says that there shall be certain noise levels which shall apply to the horns, to the noise standards, and there will be silencers installed in these vehicles. The Law of Torts, which seeks compensation for damages which are caused for the violation of a legal right, may be considered under nuisance for creation of noise levels beyond the prescribed limits. The rule was established in the case of Raylands versus Fletcher, where in that case the court stated that even if a harm comes to a neighbor without the fault of the person who's conducting that activity, or he asks another person to install certain equipment on his land which allows certain things which are not natural in nature but artificial things and which escape causing damage, then irrespective of their fault, they will be made liable. Similar act goes for the creation of noise, that if noise is being created in one place, but it affects another who might be in the vicinity or who is a neighbor in any of the meanings under the law, then he shall be affected and he shall have to pay compensation for the harm which is caused to the neighbor. The Indian cases which are dealing or have dealt with the noise or pollution, air pollution problem. One of the first cases which was there was the Kirodimal Bishambar Dayal versus the state. The accused petitioner was convicted and sentenced under section 290 of the IPC and was fined 50 rupees for causing noise and emitting smoke and vibrations by operating heavy machinery in a residential area. In the case of Bhuban Ram and others versus Vibhuti Bibhushan Bishwas in the year 1919, that is during the British period in India, it was held that the working of a paddy husking machine at night causes nuisance by noise, and the occupier was held liable to be punished under section 290 of the IPC operating at that point of time. In the case of Rabin Mukherjee versus state of West Bengal, the use of air horns was prohibited by the court to prevent noise pollution. The court observed that indiscriminate and illegal use of electric and air horn is injurious to health and noise pollution is a matter of grave concern. In the case of Bura Bazar Fireworks Dealers Association versus the Commissioner of Police Calcutta, it was held that a citizen or people cannot be made captive listeners to hearing the tremendous sounds caused by bursting out from noisy fireworks. It may give pleasure to one or two persons who burst, but others have to be captive listener and whose fundamental rights guaranteed under Article 19 and other provisions of the Constitution are taken away, suspended and are made meaningless. Similar case happened in the case of Murli S. Deora, where smoking was banned in public places because it was felt that the person who is smoking is an active smoker and the person who is within his vicinity and smoking is a passive smoker because he also is subject to the fumes which emanate from the smoking. The important case under this is the case of Forum Prevention of Environment and Sound Pollution versus Union of India, where the rules of public address system were discussed and asked to be implemented, and it was an elaborate judgment which resulted in almost evaluating all aspects of noise pollution. I will be coming down to this case in the end again. In the case of Appa Rao MS versus State of Tamil Nadu. The Madras High Court, cited in the 2005 judgment, stated that a writ of mandamus directing the state government to impose strict conditions for issue of license for the use of amplifiers and loudspeakers, and for directing the Director General Police to impose a total ban on the use of horn-type loudspeakers and amplifiers and air horns for automobiles. In the case of P.A. Jacob versus Superintendent of Police, the High Court of Kerala said that the right to speech implies the right to silence. It implies freedom not to listen and not to be forced to listen. A person can decline to read a publication or switch off a radio or a television set, but he cannot prevent the sound from a loudspeaker reaching him. He could be forced to hear what he wishes not to hear. This will be an invasion of his right to be left alone, to hear what he wants to hear or not to hear, but what he does not wish to hear. The court held that no one has the right to trespass on the mind or ear of another and commit auricular or visual aggression. A loudspeaker is a mechanical device. A person cannot put his loudspeaker to any use he likes. He cannot use these machinery to cause injury to others. In the case of Free Legal Aid Cell, Shri Sugan Chand Agarwal alias Bhagat Ji versus Government of NCT of Delhi and others in the year 2001, it was held that pollution is a wrongful combination of the environment and it causes material injury to the rights of an individual. In the matter of Hardeep Singh and others versus SDMC and others, the National Green Tribunal ordered the authorities of the Delhi government failed to comply with the directions of the Green Tribunal and directed the government to deposit a sum of 5 lakh rupees with the Central Pollution Control Board within a week and granted a month's time to the authorities to file for a compliance report for the failure of authorities in the government in controlling the noise pollution as per the statutory mandate of the Noise Pollution Rules 2000. In the case, another important case is the case of Church of God Full Gospel in India versus KKR Majestic Colony Welfare Association. The court held that it may issue directions in respect of controlling noise pollution, even if such pollution was a direct result of and was connected with religious activities. The court held that no religious prescribes that prayers should be performed by disturbing the peace of others, nor does it preach that there should be through voice amplifiers or beating of the drums and in a civilized society in the name of religions. Activities should not disturb the old or infirm persons, students or children having their sleep in the early hours or during daytime, or other persons carrying on other activities cannot be permitted. The court held that young babies in the neighborhood are entitled to enjoy their natural right of sleeping in a peaceful environment. A student preparing for his exam is entitled to concentrate on his studies without there being any unnecessary disturbance by the neighbors. The old and the infirm are entitled to enjoy reasonable quietness during their leisure hours without there being a nuisance of noise pollution, and the rights of the aged, the sick, people afflicted with psychic disturbances, as well as children up to 6 years of age, are also to be honored. So, the list of people enumerated in the case was and is effective as of any period of time, for the reason that these people are vulnerable to noise or any kind of pollution which might be created because of their age, because of their disease, or because of any other reason which may be assigned to them. In the case of K.R. Ravindran Pillai versus Pastor Prince Kaushi in 2015, they ordered the respondents a theological seminary carrying on the prayers in a privately owned prayer hall would be obliged to follow the Supreme Court directions in regard to noise pollution in this 2005 judgment. Then, a recent case of the Allahabad High Court in Pushpa Sharma versus State of UP and others delivered a judgment giving the following guidelines to the state government. The district magistrate should adequately publicity in leading newspapers regarding the directions and the rules created in the year 2000. A toll-free number will be providing the citizens to make complaints. If a loudspeaker or a public address system or a DJ or a musical instrument, a sound amplifier or any sound producing instrument is used beyond the permissible limits of the sound, a person can make a telephone complaint on the number 100 to the police or a toll-free number to the authorities. The concerned police of that area will immediately visit the spot and shall measure the noise level by the equipment, that is the noise meter application supplied to it. If there is a violation of the rules, it will stop the nuisance forthwith and shall inform the appropriate authority regarding the complaint and take action against it. No permission of DJ shall be granted by the authority for the reason that noise generated by the DJ is unpleasant and obnoxious levels. If they are operated at the minimum level of the sound, it is beyond permissible limits under the schedule of the rules. A DJ is made of several amplifiers and joint sound emitted by them is more than 1,000 decibels. They are a serious threat to human health, particularly the children, the senior citizens, and the patients admitted in the hospitals. The district magistrate or the senior superintendent of police shall convene a meeting before the commencement of any festivals like the Dashera, Durga Puja, Holi, Shabai Barat, Muharram, Easter, and Christmas festivals with organizers and representatives of the civil society to impress upon them to observe the law strictly, and the event of the failure, the legal consequences that will follow will be penalized. Thank you.